Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-Immigration. Listen, choosing immigration software without help is like arguing a case without evidence. If you're weighing your options or stuck with the system that's clunky or outdated, don't miss this. The team at e-Immigration put together a detailed software buyer's guide. It's clear, comprehensive, and made for busy attorneys who need answers fast. Head to get.eimmigration.com/resources and get the confidence to pick like a pro. Or, of course, click on the link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Apologies are in order, everyone. I am sorry. Last week, I left my show in the paws of a cat lover. Now, I admit, I knew that Liz Montana was fond of cats, but to let her cat actually appear orally on the pod? A podcast that is already full of cat? Do not tell your cat I say hi, Elizabeth. This podcast is K9. Great job last week. And on a few cases this week. I only returned from vacation on Friday, but still got 2 cases out of my own. Liz does the rest this week. Also in circuit news, and seemingly to push back on a rehearing request from Oil, the Ninth Circuit appears to have slightly amended its barn burner of aroma asylum decision, Lapidat v. Bondi, from episode 251. Do yourself a favor and check out Lapidat again, but cite to the amended decision. Also, fresh off our victory on the Haiti TPS early termination lawsuit, our TPS team filed suit again this week in D.C. District Court for the Haiti TPS termination in chief, now scheduled to go into effect in February. Time to argue about the whole shebang. Stay tuned. And finally, new patron shout-out. Happy to have you aboard Raquel Montenegro and Patricia Casares Lodi. And Michelle Mudispa and Brian Overland, too, if I didn't catch you a few months ago. I appreciate you all, and all the other patrons who rock, very much so. 5 cases this week, gonna kick it off with me with some seriousness from the Board of Immigration Appeals. Our first case this week is matter of Felix-Figueroa, published by the BIA. Starting off the episode to give this case the seriousness that the BIA believes it deserves. And hello, everyone. This case is so important that I told Liz, stop right now. I'm doing this on Friday when I return from vacay. If you even think about doing this case, we're going to have a serious issue. Liz and I then had a discussion, which I can only describe as contentious and disrespectful on many fronts, the latter all stemming from her statements, but so, here we are. This case is about drugs and the categorical approach. The current BIA members all seem to hate the categorical approach. Have I mentioned that before? And they just can't stand the isomer argument that's been affirmed by multiple circuits by applying the categorical approach based on the text of various states' drug statutes. The BIA must follow applicable circuit law when applying the categorical approach and crimmigration generally. So it's holding here that actually the realistic probability test should apply to drug isomer arguments is Probably bad law in all circuits except the Fifth Circuit, which already has a similar rule. The BIA then, likely through its Attorney General's strategy, is trying to give sympathetic judges in all other circuits ground to seek en banc rehearing and, who knows, maybe create a circuit split that the Supreme Court will take up in a year or two in an ultimate attempt to severely undermine the categorical approach in an immigration case through a crimmigration issue that, admittingly, can seem a bit silly. That is 1,000% what's happening here. Oh, to have an aggressive BIA with humane immigration issues in mind. What would that be like? I don't believe we've had anything close to that since about 2002. Certainly not in my career. Anyway, let's now do the BIA's decision. Exceptionally complicated and consequential. So you know the BIA chose a pro se case, right? And the BIA is smart, I'll admit. It looks like this case likely arises in the Ninth Circuit, given that it's an Arizona drug possession statute. While this is not how the Ninth Circuit applies the categorical approach generally, the Ninth Circuit is one of the few circuits that has not yet addressed the isomer argument specifically, or even the argument that controlled substances can themselves be internally divisible. The circuit did so years ago, but then vacated its decision and hasn't touched the issue since, to my knowledge. The BIA surely knows this. All of that is what I said before reading the decision, by the way. The BIA states that Mr. Felix-Figueroa was actually convicted of possessing methamphetamine, which is a substance listed in both the Federal Controlled Substance Act and, of course, Arizona law where he was convicted. That means he should be removable. But you see, methamphetamine is one of the types of drugs that are made of isomers, different chemical compounds or different arrangements of chemicals. So an IJ terminated proceedings. Seems that Mr. Felix-Figueroa is likely a lawful permanent resident. The IJ held that not only need not a non-citizen satisfy the realistic probability test, but even if the test applied, it would be DHS's burden to satisfy it on removability. All of that is what I believed is 1,000% correct, everywhere except the Fifth Circuit. The BIA has now said otherwise. We're talking Arizona Revised Statute, Section 13-3407. And the BIA determined in matter of PBB, Episode 13, that Arizona's possession statute, this statute, is divisible vis-a-vis the controlled substance possessed. That means here that the BIA had little trouble looking to the conviction records and ascertaining that meth was the drug possessed. But with isomers, that's only half the battle. Again, as I understand it, isomers describe different chemical ways of creating the drug at issue. Not all chemical compositions are always dangerous, and sometimes, researchers need to use them. For example, Arizona, for its part, criminalizes many meth isomers, quote, whether optical, positional, or geometric, end quote. Although the Ninth Circuit has apparently held in the past that geometric isomers don't actually exist, explains the BIA. Nevertheless, quote, in contrast, the federal statutory definition of a controlled substance also includes isomers of methamphetamine, but the statutory text defines those isomers only as optical isomers, end quote. So that's a text-based and textbook categorical mismatch, right? Arizona criminalizes possessing positional isomers while the feds don't. Categorically overbroad. Still didn't win the day for Mr. Felix-Figueroa. Relying on dicta from Moncrief that was not applied in the way the BIA is now applying it here, the BIA then cites to Duenas-Alvarez for a similar proposition, although in Duenas-Alvarez, the Supreme Court was explaining how the realistic probability test could be used by a non-citizen to show that a conviction is overbroad when textually it is a match. The reverse, of course, does not necessarily follow, as many circuits have explained. The BIA then cites to its 2019 decision in the matter of Navarro Guadarrama in support, even though no circuit has affirmed that decision's validity, and even though the 11th Circuit has since explained that that decision was based on a misunderstanding of 11th Circuit case law. Here, however, is the meat of it. To the BIA, the Ninth Circuit Court of Appeals, quote, in whose jurisdiction this case arises, has applied the realistic probability test in comparing isomer differences between state and federal drug definitions, even when the state statute explicitly lists isomers not included in the federal definition, end quote. That's United States v. Rodriguez-Gamboa from the 9th in 2020. I'm not sure that the Ninth Circuit will agree that Rodriguez-Gamboa actually resolved this issue rather than used somewhat sloppy reasoning, but hey, it's certainly an issue for a Ninth Circuit panel for another day, and hey, maybe the BIA is right about how the Ninth Circuit views the isomer argument. But on the other hand, even the BIA recognizes that Gamboa isn't necessarily on all fours here. My understanding, reading these cases and speaking with many federal public defenders, is that this matter, the isomer argument, remains very open in the Ninth Circuit. For non-citizen-friendly case law, look no further than United States v. Verdugo, out of the Southern District of California in 2023, episode 231, that postdates Gamboa. Citing outdated 11th Circuit precedent, the BIA goes on to explain that, quote, a statute's textual overbreadth does not always unambiguously establish that there is a realistic probability that the state would apply the statute to conduct falling outside the federal definition of an offense, end quote. The BIA then cites the sentence enhancement Sixth Circuit precedent in support from 2023 in the isomer context, without mentioning the Sixth Circuit's 2025 en banc decision, United States v. Saravanac, from episode 258, which appears to have definitively rejected the BIA's interpretation of the realistic probability test that it's applying now, and of course by the en banc Sixth Circuit. Now, of course, the BIA relies on the 11th Circuit's Chamu decision, but that decision rested on the fact that the 11th Circuit didn't believe that the specific overbroad cocaine isomer existed in the first place, unlike here, where all parties agree that the overbroad meth isomer exists in the real world. Nevertheless, the BIA issues the following rule, quote, based on the foregoing, we conclude that a non-citizen cannot establish that his or her conviction is not categorically for a controlled substance offense, and thereby eliminate the immigration consequences of the conviction by simply pointing to a state-controlled substance definition, including a particular kind of isomer not included in the federal definition. Rather, an immigration judge must apply the realistic probability test whenever a party asserts that a state's statutory definition of a controlled substance is broader than the federal definition of a controlled substance based on a textual mismatch regarding the isomers of a particular controlled substance. End quote. There you go. Quite the rule. Many circuits disagree. But on to burdens then, which I would think would be a short analysis explaining that DHS has the burden on removability. But neither of my assumptions are correct. The I&N and the Supreme Court's Precedential Decision from episode 45 are, of course, our guide. And Rivera held that when a statute is divisible and the record is ambiguous as to what subsection of the statute the non-citizen was convicted of, the non-citizen loses if he has the burden at the relief stage. The inverse is then true if DHS has the burden on removability. But to the BIA, Rivera was more about what happens when we don't know what crime a non-citizen committed, what subsection of a divisible statute. And that's true. Here, explains the BIA, we know that Mr. Felix-Figueroa possessed meth, and it's just about isomers. To me, that seems like a distinction without much of a difference. But expanding Moncrief beyond what the Supreme Court held, the BIA states that, quote, Pereira did not overturn the Supreme Court's instruction in Moncrief that once DHS has proven the existence of a conviction that would render a non-citizen removable, to defeat the categorical comparison, the burden is on the non-citizen to demonstrate a realistic probability that the state actually prosecutes the relevant offense in cases involving conduct falling outside the generic federal definition, end quote. Moncrief doing a lot of work for the first time now, so many years after publication. Because of that, though, DHS met its initial burden, and Mr. Felix-Figueroa and non-citizens like him retained the burden, even on removability, to establish a realistic probability that the state in question prosecutes possession of overbroad meth or other drug isomers, I suppose. Or maybe, for that matter, marijuana seeds and stems in Florida? Assuming, of course, that contrary circuit case law doesn't exist, and it's my position it does in every circuit, in some form except the Fifth Circuit. In a footnote, the BIA itself lists the Second, Seventh, and Eighth Circuits as circuits that have contrary precedent, meaning that this decision doesn't apply in the Second, Seventh, and Eighth Circuits. Again, I believe that's actually the case everywhere except the Fifth Circuit. Check the podcast page for those cases. There is no meaningful distinction between the isomer issue and other categorical approach realistic probability decisions that I can ascertain, or, for that matter, that the BIA explains. The circuit's application of the realistic probability test in non-isomer cases should bind in isomer cases as well. The BIA concludes its legal section by stating that, quote, forcing DHS to scientifically disprove every theoretical formulation of a controlled substance's isomers would clog the immigration courts with never-ending evidentiary hearings on organic chemistry and frustrate the promotion of fairness and consistency in the application of the immigration laws to non-citizens in different states, end quote. As applied here, it meant proceedings were remanded for Mr. Felix-Figueroa to meet his burden, ensuring this case wouldn't go on direct petition for review to the Ninth Circuit for a very long time. So, the BIA seems to be saying that non-citizens always bear the burden under the realistic probability test and that it always must be met with isomers? Again, I don't see how isomers are different than other textual overbreadth categorical approach analyses, so I look forward to seeing this case bleed into other areas of immigration with the BIA until and while the circuits step in. It's going to be a chaotic few years, everybody. To be very clear, because I've been doing a lot of side-talking this case, quote, to succeed with his positional isomer argument, the respondent must establish a realistic probability that Arizona would actually prosecute conduct involving a particular positional isomer of methamphetamine that is not federally controlled, end quote. Wild stuff. If anyone loses a case relying on this decision and would like me to take it up to the circuit, hit me up. And that is matter of Felix-Figueroa.
Next up, Rivera Samayoa v. Bondi, published by the First Circuit on July 28, 2025. This case is about cancellation of removal's exceptional and extremely unusual hardship analysis, and is a good example of why detailed, individualized, and well-documented evidence is absolutely critical to such a claim. Mr. Rivera is a native and citizen of Guatemala. He entered the United States without inspection in 1996 and has lived in Massachusetts ever since. He has 4 U.S. citizen sons and is his family's main provider. He asserted that his removal from the United States would jeopardize their health, education, and well-being. Mr. Rivera's eldest son was born in 1998 and now lives in New Jersey. He suffered with asthma as a child, but now has no significant health issues and stays in touch with Mr. Rivera, who provides some financial support. Mr. Rivera's other 3 sons have all had various health issues. His second son was born in 2005 and contracted lead poisoning as a young child, which now causes him to experience aches and pains and to receive extra help in school. According to the IJ, however, this son is, quote, medically stable, end quote. Mr. Rivera's third son was born in 2012 and was diagnosed with anemia and had blood circulation issues as a toddler. He still gets migraines, but has been stable for 4 years. Mr. Rivera's fourth and youngest son was born in 2015 and also had anemia and severe nosebleeds, requiring hospitalization once. However, according to the IJ, this too is now under control. After living in the United States for 20 years, Mr. Rivera was placed in removal proceedings and charged as inadmissible under INA Section 212A6AI. Mr. Rivera conceded removability, but sought cancellation of removal under INA Section 240A(b). The IJ found that Mr. Rivera met the first 3 requirements for cancellation of removal. He had continuous physical presence for over 10 years, he had good moral character, and he had no disqualifying convictions. But the IJ denied relief on the 4th requirement, finding that Mr. Rivera had not shown that his removal would result in exceptional and extremely unusual hardship to his U.S. citizen sons, because the hardship that would be suffered was not, quote, substantially beyond the ordinary hardship that would be expected when a close family member leaves the country, end quote. The IJ did grant voluntary departure and briefly mentioned that Mr. Rivera might be able to seek lawful reentry later through sponsorship by his eldest son. Mr. Rivera appealed, and the BIA affirmed the IJ's decision and agreed that there was insufficient evidence that the children would be unable to obtain necessary medical treatment or that the hardships, when considered cumulatively, rose to the required legal threshold. The BIA also noted that while Mr. Rivera hadn't stated whether his children would remain in the U.S. or go with him to Guatemala, the record didn't establish that they would suffer the required level of hardship in either reality. Mr. Rivera then petitioned for review to the First Circuit and raised 3 arguments. The First Circuit began by clarifying its jurisdiction to review each argument. The First Circuit recognized that under Wilkinson v. Garland and Patel v. Garland, courts cannot review factual findings in cases for discretionary relief, but they can review legal questions and mixed questions of law and fact. So, what could the court actually review here? The First Circuit stated that it did have jurisdiction to review Mr. Rivera's main argument, that the cumulative impact of his removal will cause exceptional and extremely unusual hardship to his sons because it is a mixed question of law and fact. The First Circuit did not have jurisdiction to second-guess the IJ's factual findings that Mr. Rivera asserted were erroneous. Specifically, the finding that Mr. Rivera's children were comfortable with the Spanish language and the way of life in Guatemala, the finding that Mr. Rivera's sons were healthy and medically stable, and the finding that Mr. Rivera's eldest son could aid in his lawful reentry. But the First Circuit did have jurisdiction to review whether the agency ignored relevant evidence, which would be a legal error. So the court had jurisdiction to review 2 main arguments. First, whether the agency ignored relevant evidence related to the children's medical treatment and education, and second, whether the agency properly considered the cumulative impact of Mr. Rivera's removal. Unfortunately for Mr. Rivera, the First Circuit rejected both of these arguments. On medical treatment, the First Circuit noted that Mr. Rivera offered only generalized statements about the cost of care in Guatemala, but didn't provide evidence showing that the children couldn't receive adequate care there. Similarly, there was no evidence that the children's educational needs couldn't be met abroad. The BIA did acknowledge Mr. Rivera's one son's slower learning pace and the family's use of Spanish at home, and concluded that these factors didn't create an exceptional hardship. As for the country conditions in Guatemala, while Mr. Rivera submitted reports about poverty and crime, he didn't show how these conditions would specifically affect children in a way that meets the high statutory threshold. Ultimately, the court saw, quote, no reason to believe the agency failed to marshal and weigh the relevant hardship factors cumulatively, end quote, and stated that Mr. Rivera had, quote, not shown that the agency committed legal error by overlooking or otherwise failing to consider relevant evidence, end quote. While the First Circuit expressed regret that it could, quote, do nothing more for petitioner and his children, end quote, it emphasized that, quote, the law places a daunting standard before applicants for cancellation of removal, and Rivera did not meet his burden, end quote. And so, the First Circuit denied Mr. Rivera's petition for review. And that was Rivera-Samayoa v. Bondi.
Are you fighting like a maniac, completely overwhelmed by the chaos of the new administration? Immigration policies are shifting fast, the pressure is piling up, and clients are desperate for help. You're working around the clock, but there's only one of you. Well, Staffy's got your back. Staffy's bilingual virtual paralegals and administrative assistants handle USCIS forms, client intake, evidence gathering, and scheduling, so you're not drowning in paperwork while trying to fight for your clients at the same time. Stop running on empty. Staffy gets you a trained, ready-to-go team fast with HR-backed support, onboarding, and continuous training. You don't have time to do it all alone, and you don't have to. Schedule a consultation at staffy.cc, that's stafi.cc, and claim $500 off your first month. Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez Immigration Bonds take it from there. They help families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, But that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez and Gonzalez, families get hands-on help throughout the entire process, and they typically issue refunds within 1 to 2 weeks of receiving the I-391 bond cancellation notice. Tired of being the point of contact for every bond question? Let Gonzalez and Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your client stay in the country. You can reach Gonzalez and Gonzalez at 833-409-9200. Their fee? Just 2% plus $40. And for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They got those too. They're family-owned and have been in business for 75 years. Gonzalez & Gonzalez Immigration Bonds. Efficient, supportive, and trusted. Visit immigrationbond.com, click on the link in the show notes, or call at 833-409-9200.
Next up, Real v. U.S. Attorney General, published by the Third Circuit on July 30th, 2025. This case tackles the one-year asylum filing deadline, due process challenges, and the ever-narrowing scope of appellate jurisdiction. It also features a strong dissent, raising questions about how courts should interpret, or if they can even interpret, the extraordinary circumstances exception at I&A Section 208 A2D. Let's get into it. Mr. Real is a native of Colombia, where he participated in anti-government protests over economic and educational conditions. According to his testimony, this led to multiple arrests and beatings by Colombian police. In March 2022, Mr. Real fled to the United States with his wife and son. He did not enter through a port of entry, but turned himself in to immigration authorities shortly after crossing the border. ICE officers gave him a government-issued cell phone, released him with his family the next day, and told him to check in regularly and appear for a court hearing in 2025. But they never issued him an NTA, never asked about a fear of return, and never advised him of the one-year filing deadline for asylum. Roughly a year later, Mr. Real was arrested in a domestic dispute. Shortly afterward, DHS issued an NTA charging him as inadmissible under INA 212A6AI. In July 2023, 16 months after his arrival, Mr. Real filed applications for asylum, withholding of removal, and cat protection. At his hearing, the IJ found that Real had suffered persecution in Colombia and granted him withholding of removal. But the IJ denied asylum. The reason? Mr. Real had missed the one-year filing deadline and failed to show either 1. Extraordinary circumstances under INA Section 208 A2D to excuse the late filing, or 2. Membership in the Mendez-Rojas settlement class, which provides exceptions for certain late filers. The IJ also noted that ignorance of the law isn't enough to excuse a late filing. The BIA affirmed, emphasizing that lack of knowledge about the deadline doesn't count as an extraordinary circumstance under the statute. Mr. Real petitioned for review to the Third Circuit, raising two arguments. First, that the government's failure to notify him of the one-year filing deadline violated his Fifth Amendment due process rights. And second, that his circumstances nonetheless qualified as an extraordinary circumstance, excusing the late filing under INA Section 208 A2D. But the Third Circuit rejected both arguments. As to Mr. Real's due process argument, the court began by reaffirming that due process protections do apply to non-citizens, even those present unlawfully. But Mr. Real's argument that the government's failure to affirmatively notify him of the one-year filing deadline was unconstitutional was flatly rejected. Mr. Real relied on the Supreme Court's 1950 decision in Moulin v. Central Hanover Bank and Trust Co. and argued that by not informing him of the one-year filing deadline, the government failed to provide notice, quote, reasonably calculated under all the circumstances, end quote, to apprise him of his rights under the INA. But the Third Circuit didn't buy it. In fact, the court stated that, quote, Real's case is a far cry from Moulin, end quote, because, quote, "This case concerns the government's alleged obligation to notify an alien of his rights under a generally applicable immigration statute. That statute is published in the United States Code, and implementing regulations are published in the Federal Register. In the mine run of cases, that is enough to provide constitutionally sufficient notice of the law's contents." End quote. In short, according to the Third Circuit, laws published in the U.S. Code and the Federal Register provide constitutionally sufficient notice of statutory requirements. The court also distinguished Mr. Real's case from its prior decision in United States v. Charleswell and the Mendez-Rojas decision because those cases involved misleading or confusing notices that contributed to due process violations. Mr. Real, according to the Third Circuit, didn't point to any misleading documents or instructions, just the lack of notice. And that wasn't enough. Next, Mr. Real argued that even if due process wasn't violated, the court should still review the agency's finding that no extraordinary circumstances excuse his delay. Here's where things get more complicated and controversial. The majority held that it lacks jurisdiction to review that finding. Under Section 208A3 of the INA, quote, "No court shall have jurisdiction to review any determination of the Attorney General under Paragraph 2, end quote, which includes the extraordinary circumstances exception at Section 208A2D. And although 8 U.S.C. Section 1252A2D preserves jurisdiction for constitutional claims or questions of law, the majority said this didn't apply here. But why not? Because, according to the majority, Section 208A2D of the INA requires the applicant to prove extraordinary circumstances, quote, "to the satisfaction of the Attorney General," end quote, a phrase that, in the majority's view, signals a discretionary decision, not a reviewable legal one. The court acknowledged Guerrero-Lasprilla and Wilkinson, which preserved review of mixed questions of law and fact. But the majority said those cases didn't apply here because neither involved this specific statutory language about satisfying the Attorney General. The bottom line, the court denied the petition as to the due process claim and dismissed it as to the extraordinary circumstances claim for lack of jurisdiction. Judge Fisher dissented as to the second argument, asserting that the court should have jurisdiction to review whether Mr. Real met the extraordinary circumstances standard under Section 208A2D of the INA. And, exercising this jurisdiction, Judge Fisher stated that he, quote, "would conclude that Real met the standard for extraordinary circumstances," end quote, and, quote, "would therefore grant his petition, vacate the BIA's dismissal, and remand for the IJ to consider granting asylum in the exercise of discretion." According to the dissent, the extraordinary circumstances standard, quote, "is indistinguishable from the Guerrero-Lasprilla equitable tolling question, as it likewise requires application of a legal standard to establish facts," end quote. And the implementing regulations at 8 CFR 1208.4A5, quote, "provide a non-exhaustive list of possible extraordinary circumstances, including what kinds of events qualify, how proximate the cause must be to the delay, and what evidentiary burden applies," end quote. While these are fact-intensive considerations for the IJ, quote, "they also implicate legal criteria and therefore legal judgment," end quote, similar to the due diligence inquiry deemed reviewable in Guerrero-Lasprilla and cancellation of removal's exceptional and extremely unusual hardship standard deemed reviewable in Wilkinson. Having concluded that he would review the merits of Mr. Real's extraordinary circumstances argument, Judge Fisher then stated that the BIA did err in refusing to excuse Mr. Real's late filing because Mr. Real was misled. Mr. Real presented himself to authorities and did what they told him to do, check in and await a hearing, and he reasonably believed that he would have an opportunity to present all his claims. But despite being asylum eligible, Mr. Real was never asked if he had a fear of return. He was given no credible fear interview, no information about the asylum process, and at no point was he informed, verbally or in writing, of the 1-year filing deadline for asylum. And then he wasn't issued an NTA for over a year. Judge Fisher also stressed that there is, quote, "no bright-line rule that publication always constitutes sufficient notice," end quote. And in fact, quote, "courts have found that a statute alone is insufficient when paired with misleading instructions and personal vulnerabilities," end quote. According to the dissent, Mr. Real had such personal vulnerabilities and received such misleading instructions. Quote, Real relied on a Spanish-speaking court interpreter because he lacked English fluency. He had no legal guidance, and he was grappling with past trauma that would later be considered credibly established and adequately corroborated. Viewing the record objectively, there were no red flags that would alert even English-speaking, reasonable non-citizens that they needed to take further action after being processed, released, and given a court date. The government lulled Real into inaction, end quote. According to the dissent, quote, the government's conduct not only misled Real, but it actively deprived him of a meaningful opportunity to comply with the law. If this does not constitute extraordinary circumstances, it is difficult to imagine what does, end quote. Judge Fisher concluded his dissent by warning, quote, of the consequences of insulating these agency determinations from judicial review, end quote. As Judge Fisher noted, Mr. Real met the higher standard for withholding of removal, and thus, quote, misapplication of the extraordinary circumstances standard can prevent even meritorious asylum seekers from having their claims heard, end quote. But the majority disagreed. And that was Real v. U.S. Attorney General. Next up, Navarro v. Bondi, published by the Fourth Circuit on July 31st, 2025. This case involves a former MS-13 member from El Salvador who sought protection under the Convention Against Torture and raises some weighty issues: credibility, omissions in asylum filings, expert evidence, and a dash of issue exhaustion at the end. Let's get into it. The petitioner, who goes by Colorado, was a former member of MS-13 in El Salvador. He joined the gang at 17, committed violent crimes including the murders of 3 rival 18th Street gang members, and was twice arrested for, quote, illegal aggravation, end quote. There were also outstanding Salvadoran arrest warrants for aggravated homicide and terrorist activity. Colorado claims that he left MS-13 and fled to the United States without permission. Since then, he says, the gang has greenlighted him for death and issued threats. He argued that if returned to El Salvador, he'll be tortured either by the government or with its acquiescence, especially if he ends up imprisoned. DHS issued an NTA in 2022. Colorado conceded removability and filed for asylum and cat protection. Over the course of the proceedings, he submitted 3 asylum applications. In the first application, he falsely claimed that he was falsely accused of MS-13 membership. In the second application, after the government submitted his arrest warrants, he admitted to being in MS-13, said he joined to protect his sister, and disclosed 2 arrests, but still omitted any mention of the murders. In the third application, he referenced having done, quote, activities, end quote, with the gang, but declined to put them in writing, promising to testify orally instead. At the merits hearing, his lawyer proffered that Colorado had killed someone in El Salvador. Colorado then testified and admitted to participating in 3 murders. He also acknowledged under oath that he'd lied on his first 2 applications. Despite these serious omissions and inconsistencies, the IJ found him, quote, generally credible, end quote, because Colorado's explanation that, quote, he was afraid of officials in El Salvador possibly getting a hold of his application and seeing the admissions and raising additional scrutiny on him, end quote, was, quote, not unreasonable based on what is going on in the prisons of El Salvador, end quote. The IJ found it likely that Colorado would be tortured if returned, whether by the government directly or by gangs in prison with government acquiescence. The IJ then granted cat protection. DHS appealed, and the BIA reversed the IJ's decision on both key points. First, on credibility, the BIA found clear error in the IJ's credibility determination. Colorado had repeatedly omitted critical facts, like the 3 murders, in sworn documents and only confessed after government evidence forced his hand. The BIA was unpersuaded by his claimed fear of official reprisal through written applications, pointing out that he was already charged in El Salvador and disclosure wouldn't increase his legal exposure. The BIA also highlighted that he had previously affirmed, under oath, that the first application had been read to him in Spanish and that he knew its contents. The clincher? On appeal, Colorado admitted he had omitted the truth because it might hurt his case, a reason the BIA saw as an admission that his other justifications were pretext. Second, on the likelihood of torture, the IJ had concluded that Colorado would likely be tortured in Salvadoran prisons or by rival gang members. But the BIA found those conclusions unsupported by the record. The statistical data didn't show that torture was more likely than not. For example, the BIA concluded that the evidence showed that out of 95,000 detainees in Salvadoran prisons, only 55 had reported torture, a rate of about 0.057%. The BIA said that doesn't meet the CAT standard of more likely than not. The BIA also pointed out that the IJ ignored government reforms and anti-torture initiatives in El Salvador. As for gang-related torture, the BIA found there was no specific documentary evidence, just Colorado's testimony, which it had already found not credible. Finally, Colorado tried to rely on an expert report, which said he faced a 100% chance of torture. But the IJ never referenced that report in the decision, the expert didn't testify, and when given the chance to call the expert, Colorado declined, based on the IJ's off-record assurance that relief would be granted without the expert. Because of this, the BIA said the expert report was less probative without testimony, cross-examination, or any credibility assessment by the IJ, and did not credit it. Colorado then petitioned for review to the Fourth Circuit, and the Fourth Circuit denied the petition in full. On credibility, the court said that the BIA's conclusion was more than reasonable. Colorado's omissions, shifting explanations, and contradictions in sworn statements amounted to a, quote, trail of evasion, omission, and blatant fibs, end quote, that left the court, quote, convinced that substantial evidence supports the board's conclusion that the IJ clearly erred in its credibility determination, end quote. On the likelihood of torture, the Fourth Circuit held that the BIA correctly concluded that the IJ had relied on speculation and insufficient statistical evidence. While the Fourth Circuit stated that, quote, any deaths are regrettable, this evidence does not show that it is likely that Colorado will face torture by the Salvadoran government, end quote, because the numbers just simply didn't add up to more likely than not. The Fourth Circuit also stated that the IJ's decision regarding torture by gangs, quote, lacks any citations to documentary evidence, end quote, besides Colorado's testimony, which was properly found not credible by the BIA. Quote, given this dearth of evidence, it is no surprise that the IJ's findings were rejected for clear error. On the expert report, the Fourth Circuit rejected the argument that the BIA failed to consider it. Instead, the court explained that the BIA did consider the report, but just rejected it because it reasonably determined it had very weak probative value, given that the expert didn't testify and the IJ didn't rely on the expert. And finally, the court rejected Colorado's argument that the BIA should have remanded to take the expert's live testimony. The claim hadn't been exhausted at the BIA level, so the court lacked jurisdiction to consider it. And that was Navarro v. Bondi.
Concluding was Sanchez-Banos v. Bondi, published by the Eighth Circuit on August 1st, 2025. I'm back! This case is about administrative closure. Mr. Sanchez-Banos was from Mexico and entered the United States without authorization in 1998. Well, that's a bit generous of the Eighth Circuit. He was 2 years old, so he didn't have much say in the matter, which is why the Obama administration created and granted him DACA. But he lost his DACA when, about 20 years or so after entering the U.S., he amassed 3 criminal convictions. And he was placed in removal proceedings where he applied for non-LPR cancellation of removal. Eventually, during removal proceedings, he wanted to seek an I-601A waiver based on his marriage to a U.S. citizen. He wants the consular process abroad, but the second he leaves the U.S., he'll be barred from re-entering for 10 years. Hence, the waiver, if he can show extreme hardship to his U.S. citizen spouse, should he not be allowed to return. And thanks to Obama-era regulations, he can apply for that while in the United States before he leaves and triggers the bar. But for reasons that I've never understood, the regulations also require that removal proceedings be administratively closed or terminated before USCIS can even consider an I-601A waiver application. Like, why? Literally required to do this, Mr. Sanchez-Banos moved the IJ for administrative closure. DHS did not oppose the motion. The immigration judge denied the motion. I can only imagine Mr. Sanchez-Banos did not submit his proposed I-601A packet with the immigration judge. Always good practice to do so. I say this because the IJ stated he, quote, has no ability to determine how USCIS will exercise its discretion or whether they will find that the extreme hardship elements have been met for the waiver. As such, it is difficult for this court to determine the likelihood of the respondent's waiver application, end quote. The BIA affirmed. Whether to administratively close is, after all, a balancing test requiring consideration of multiple factors. Although the BIA has led me to believe in recent weeks that DHS's position is really, really important, the 8th Circuit affirmed the agency. Not too long of a decision, the court first discussed how the IJ and BIA must consider the matter of Avetisyan factors, but that the agency need not recite them, quote, mechanically when applying them to the facts, end quote. Now enshrined in regulation, by the way, too. Although counsel explained some of the hardship orally, it seems that yes, indeed, the IJ was not provided with any actual hardship evidence to consider. Plus, explains the 8th Circuit, even Mr. Sanchez-Banos' attorney mentioned that I-601As were, at the time, taking 32 to 36 months to decide. A delay of USCIS's own making that somewhat paradoxically undermines an admin closure motion. Don't worry about delays, everybody, though. With all those increased fees, I'm sure USCIS will be hiring multiple new adjudicators to make everything go quicker. Don't get me wrong. I can only assume that Mr. Sanchez-Banos didn't put together a huge administrative closure filing, knowing or anticipating that DHS wouldn't oppose, which it didn't do in this case, recall. But assuming what a judge will do, even when a party does not oppose, can be a dangerous game to play. And Mr. Sanchez-Banos lost his case. And that is Sanchez-Banos v. Bondi. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Att'y & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.